Today's episode is sponsored by Shameless Security. They are a provider of cybersecurity solutions focused on the middle market. They combine human intelligence with technology to secure your investments. Shameless Security works with private equity firms, venture capital organizations, and family offices to identify the technologies and services needed to defend, fortify, and secure their acquisitions' cybersecurity posture. Partnering with Shameless Security enables organizations to close pathways of attack, remediate vulnerabilities, reduce risk while meeting compliance requirements. I've gotten to know Craig Sherwood at Shameless and some of the cyber M&A work they have done, and I'm very impressed. I want to thank them for sponsoring and hope you enjoy today's episode.
Looking to buy, sell, or grow your business to position it for a sale? As the owner and managing partner of Sun Acquisitions, Dominic Rinaldi has personally been involved in over 300 M&A transactions. He has seen and done it all, consulting with large and small businesses across a broad range of industries. On M&A Unplugged, he'll interview buyers, sellers, and their advisors about their experiences scaling, selling, and acquiring businesses. On every episode, you will get key learnings, but most importantly, you will be better prepared for your own acquisition or sale. This is M&A Unplugged with your host, Dominic Rinaldi.
M&A Unplugged community, have you ever wondered what the differences are between copyrights, patents, and trademarks? Do you understand the difference between use rights and registration? Have you considered the importance of trademark diligence in your M&A transactions? Well, we are being joined today by Andrea Fuelleman, who is a partner at the law firm of Neil Gerber Eisenberg. Andrea focuses her practice on brand protection and intellectual property enforcement matters. I think this is an area of M&A that is often overlooked, and Andrea really opened my eyes to the importance during a recent conversation. Andrea, so happy to have you here. Welcome.
Hi, thank you very much. I appreciate it.
So Andrea, maybe just a quick background on yourself and your firm.
Sure. So I am an associate at the law firm of Neil Gerber and Eisenberg. And Neil Gerber is a global law firm here in Chicago, founded in Chicago. And it's actually one of the largest single office law firms in the nation. Our practice is both international and domestic in scope and includes transactions of a lot of different types of businesses, including litigation and intellectual property, which is what I practice in. So I've been doing the intellectual property work with Neil Gerber for about 8 years now, and I join about 40 other intellectual property attorneys at our firm.
Well, that's great. Well, it's going to be perfect for this conversation then. So let's start with the obvious question that I get asked quite a bit, which is, what is the difference between a copyright, a patent, and a trademark?
So copyright, patent, and trademark are all different types of intellectual property rights, but they cover different types of works. So patents protects inventions of new processes and methods and certain types of designs. And rights and patents are gained when a patent is registered with the U.S. Patent and Trademark Office. Copyright, on the other hand, it protects creative expressions of original works. So this would include things like books, screenplays, musical compositions, and other creative works. And then the third type of IP is a trademark. And this is different than a copyright because it's the word, the phrases, a symbol or a logo that you would use to identify your company and your brand from others. So it's the difference between an invention, the creative expression of an original work, and the word or logo that you use to identify yourself. So those are really the three main categories of intellectual property rights.
Well, thank you for clearing that up. That makes a lot of sense. Although in application, sometimes I think people could be confused about where these overlap sometimes. I'm interested in the copyright part of this. If you write original content, so it's not a book or a screenplay, but it's just regular content that you're putting up on your website or anything like that, and you think that it's very unique, I mean, is that potential for a copyright?
It is. The original content that you put on your website, so even if it's just the text that you use to describe what you do, or if you take photographs that you're using in your marketing materials that are displayed on your website, those aspects of the website are copyrightable.
Got it. So let's talk about the process. What's involved if somebody's got, let's maybe focus in on trademarks for a second. and go down that path. If somebody is interested in understanding, if what they have is worth trademarking, what's the process that they go through?
So the first step in establishing a trademark right is choosing what you think is a good mark. There's a variety of different types of trademarks in terms of strength. So the strongest mark is an arbitrary mark. So that's something where the mark is unique. It doesn't really, you say the word and it doesn't really mean anything to the customers or the audience in terms of, if the word isn't descriptive. Marks that are descriptive, meaning you say the word and it describes what the goods or services are, that would be considered on the spectrum more of a weak mark. Whereas on the other end of the spectrum, an arbitrary mark, so for example, Apple for computers, that's a stronger mark. So when you're trying to determine what mark makes the most sense to your company, you want to try to stay on the stronger end of the spectrum than the weaker, because that would definitely help you establish the trademark rights.
So, I see lots of businesses with similar names or similar product names, and maybe there's slight variations, but they're common names. And, I'm struggling now to think of one, but you see it all the time, right? You see XYZ business in one area, and then you see them in another area, or you see product names that are very similar. I mean, potentially, are people violating trademarks when they do this?
It really depends. And it depends on things like how the mark is being used and with what goods and services. So unless you're a famous mark, so for example, McDonald's, if you were to open up a retail store that sells computers under the name McDonald's, because McDonald's is such a famous mark, they really do have broad rights over almost all types of goods and services. But on the other hand, if the mark isn't what we would consider famous, your rights in that mark only extend to the goods and services for which it's used or which it's registered for. So that means you may see a lot of companies operating under similar or even the same type of mark. But if they're operating in different scopes of use, for example, with different services, with different goods, or even in different geographic areas, those are factors that would help avoid or mitigate the potential for confusion or the potential for infringement.
So the little research that I did on this subject, there was something that I came across called a class. Is what you're talking about akin to a class? So you pick a class as sort of a sector or a part of the industry, and you're using your trademark in that class. Is that the proper use of that?
That's a really good question. And yes, the class does describe what the area of goods are. So the class comes into play when you are registering your mark. So when you register a mark, you have to apply for the mark within a particular, what they call international class. So for example, class 9 covers things like electronic goods, headphones, speakers, things like that. Whereas class 41, for example, would cover things like entertainment services. So depending on how you use your good, in what field, that would determine what class you fit into. So that's a really good starting place of determining if you see someone else using your mark, or if you see someone else using a mark that you like, see what class they're using it in and see where your mark falls. And if there's an overlap, then there's definitely a potential for confusion or infringement down the road. So the class heading is really a good starting place to determine where you fall in that spectrum.
So, okay. So let me, just to be illustrative here, I've got a company, I'm going to call it ABC, and ABC operates in the entertainment space, and to use your example, but then there could be another ABC that operates in the financial services. And as long as they don't overlap, they can each own that name, that trademark, or their products or whatever in those classes. Correct? Do I have that right?
That's correct. So you could have 4 or 5 different companies operating under the exact same mark, but in completely different sectors and completely different fields. And they can continue to operate under that same mark without having any confusion, because they're operating in different among different services or goods.
So how broad are these classes? Are these classes very broad, or some of them narrow?
It depends on which class. So the one example you just mentioned about financial services, that's a fairly broad class, because the way trademark infringement, the analysis of trademark infringement goes, is that it doesn't require that the services or even the marks be exact, but that there's a potential for confusion, a likelihood of confusion. So if the goods are deemed to be related or even complementary, or would fall under the same umbrella, that could make the class broader. But if, on the other hand, you're using your mark in connection with very specific goods and services, and you may have it registered with those very specific goods and services, that makes the argument that the use is very broad much more difficult to make. So, you mentioned at the very beginning of the intro the difference between use and registration. I think the way you describe the mark in the trademark registration or the trademark application is a really good example of why that's important in terms of differentiating the broadness of the use.
Understood. So what's your advice to people? And I'm assuming it's going to be do this work as early as possible and as often as you think it's meaningful to your business. But what do you normally tell business owners who are, contemplating, content or names or products and services? How do you work with them?
Yeah, well, you hit it on the nail when you first mentioned about starting early. I think one of the most important things about adopting a trademark or a new slogan or product name is to start early. It's easier to choose a good mark and develop rights in a good mark early on in the process when you know that there aren't any other obvious obstacles, potential infringements, than starting to use it, putting the money behind the mark, putting the money behind the slogan to find out a year or two down the road that someone else is using the exact same mark, the exact same services. Because at that point, if you run into an infringement issue and have to change the mark or change the name of the slogan that your customers have now become to identify with you, it becomes expensive and it becomes confusing to your customers. So in terms of best practices, we always advise our clients to clear the mark early before you start to use it.
So how expensive is it to actually go through this work up front, order of magnitude? And a couple of layers to this question. Is it just for the US or is it international as well? And what's the shelf life of this work?
So when you register a mark in the US, you're getting rights to the mark within the United States, but there are similar trademark registration systems around the world. So just by having use in the United States doesn't necessarily mean that those rights are enforceable in other jurisdictions. Same thing if you're using it in Europe only or in the UK only, that doesn't mean you have an enforceable right in the US. So if you are a worldwide company or have plans to expand beyond the United States, it is advisable to register the mark in other countries, and that can certainly increase the cost of obtaining a mark, but as well as enforcing the mark. But just looking at the US, the process involves a couple different steps. The first being running a preliminary knockout trademark search, and that's to identify whether there's any existing registrations or applications for the same or similar mark for the same or similar services. Then, depending on the results of that, you may want to get a deeper dive by doing a more comprehensive trademark search, which will look into common law, meaning unregistered uses of the trademark, to see what else is out there in the marketplace beyond what's just registered on the U.S. Trademark Office website. So once you've run both of those reports, or just one or the other, and are comfortable with the risk, and of course there's always a risk that the adoption of any mark, there could be some unregistered use that you just haven't disclosed that come out of the woodworks, which is always a risk with trademark rights. But once you're comfortable with that risk and make the decision to file the trademark application, the actual application process is fairly inexpensive. The filing fee is about $275 just for the USPTO cost. But of course, the attorney time and preparing it, making sure the description, the class designation, the specimen, and then also the preliminary searches can increase the cost of getting an application on file.
You threw a new term in there for me, specimen. Can you talk a little bit about that?
Certainly. I use the term so frequently. A specimen is just a fancy word for saying example of use.
Got it.
When you apply for a trademark application, you won't be able to actually get a registration for it until you can prove that you're actually using the mark with the services that you've applied for. So a specimen is really just an example of your use of the mark. So for example, if your services are in the financial field, you could submit a screenshot of your website that includes the description about us, services we offer, or a brochure. If your goods are headphones speakers or consumer electronic products, you could submit something like a photograph of the product that bears the mark or the product packaging. So in order to perfect your rights in the mark, you have to actually use the mark.
Understood. Okay. So let's move over to M&A transactions and talk about how this comes to play in M&A transactions, because I don't see that a lot of buyers undertake this sort of diligence when they do their transactions. And I'm wondering, A, what's your advice there? And two, do you have any experience where people didn't do this sort of work and they had a surprise that wasn't a pleasant one?
Yeah, I think it's important going into an M&A deal that you don't overlook intellectual property rights. I think it's obvious. The patent rights, that seems like an obvious one. You want to make sure, that's one of the reasons why you register patents, is to be able to monetize that and profit off of that when you enter into a sale. But often trademark rights can be deemed as either less valuable or less important or forgotten altogether, but it shouldn't be. Because the trademark really is the brand identity. It's what your customers call you. It's what they refer to when they are asking for your product. And it's important to know at the end of the deal, is that mark still going to be used? And if so, who's going to be using it and who owns it? And these are all different types of questions and provisions that should be included in the M&A deal. And there's a recent one that I worked on. The deal in this case really did involve, the brand was a big aspect of the deal. And it was really important to be very thorough and very complete in identifying all the potential risks, all the potential enforcement efforts down the road, because the buyer and the seller were both making substantial reps and warranties with respect to these rights and the ownership of the rights, that it's important that when you go into these deals, you have a very good understanding, both on the buy side and the sell side, of what you're getting, because you would hate to enter into a deal, spend a lot of money to acquire these assets, to find that either the entity you're purchasing them from didn't have rights in them, or was already facing very significant challenges that undermines those rights.
Any situations where you saw an outcome that was less than favorable because people didn't do this work?
There are always less than favorable outcomes, but the first example that comes to my mind of matters that I've worked on, it ended up being, there was a very strong silver lining in this particular case. I had a client who had acquired a trademark right through an acquisition, and the mark at the time seemed just right. They developed a new website, their new marketing materials, and they started to get investors on board. But then as they were trying to register or update the registration details, we found out that down the chain of title, unbeknownst to my client, there was a break, meaning someone that perhaps it was maybe someone in the entity that, or the trademark was listed in the name of someone that it shouldn't have been within the company, as opposed to the entity name itself. And in any event, the break in the chain of title made it what should have been an easy assignment issue, more of a challenge. And a third party picked up on that and tried to use that against us to allege an infringement action. But once we were exploring our options in terms of, do we fight this and do we go back and try to perfect this chain of title, or do we look around and see, perhaps another mark that makes more sense? And in this particular example, based on what this client's plans were to enter into the market and to expand their use, it turned out that the earlier mark didn't really resonate as well with the customers as some of the new marks that they were considering, based on what they were doing in the market anyways. So it ended up being that this example of the chain of title issue ended up being an opportunity to reach out to their customers and adopt a new name that actually made more sense and resonated better with their customers.
But it is still a cautionary tale, because somebody picked it up and was ready to maybe do battle over that trademark. And silver lining for sure, because your client pivoted, and it sounds like maybe they got a better mark anyway that resonated better with their clients, but still points out that, people are watching this stuff and you have to be careful when you're going to market.
Absolutely. People are always watching for these things. And, it can be a very expensive endeavor, especially if you're a small middle market company. You're not necessarily budgeting for trademark infringement battles. You want to put your research and development into putting your product out in the market and getting your customers to buy into it. So, that brings me back to the point I made earlier. It's important to clear the mark early because it just becomes a thorn, becomes challenging, it becomes confusing to your customers to pivot to a different mark after years of operation under the same mark down the road. So we always advise, again, to start that process early. And if there's any question as to whether if you acquire a mark either through an M&A or through an assignment or any other type of transaction, definitely work with an experienced attorney to look through those records and make sure that there isn't a break in the chain of title, because those can end up with the same type of issues, even if it's not an infringement to an initial infringement.
Yeah, makes perfect sense. And, out of the three, the copyright, patent, and trademarks, to be fair, I do see people spend time on the patents. I mean, it seems like that's the one that gets the most attention. I don't see a lot of attention on the copyright and the trademarks. And I think it's, they get tied up in the patents and forget about the rest of this. Let me shift gears a little bit further here as it relates to laws. So are there any changes in the laws that are coming or anything that's happened in the recent past around copyrights, patents, or trademarks, whether it's, in the US or internationally, that impacts how people perfect all of these?
I know that at least internationally, so in the United States, as I mentioned earlier, you have to prove use of your mark to register it. In other countries, you could just file a trademark application, pay the registration fee, and get a registration. Mexico is an example of this, where they've recently changed their laws over the past year or two, where they do now require use of a mark. So before, where brand owners in the United States were trying to get a foothold in the international market by filing a lot of applications and maintaining registrations all around the world, now that some of these laws are changing, they're seeing that they have to let some of these applications and registrations go because they can't perfect their use. They can't sign that declaration attesting to the fact that they're using that mark in that particular market. So we are seeing some changes internationally where some of the laws are becoming more similar to what we have here in the United States, where you can't just claim rights to a mark to prevent others from using it. Rather, you have to actually have rights in it by using that mark in that particular country.
Really interesting. As you talk about that, it kind of reminds me of what happened with domain names. People just, it's like a land grab, and people were grabbing all these domain names, even if they had no plan to use them. And then, it's become quite a big business, right? Grabbing a domain and reselling it. It almost sounds like that's what's happened internationally. People squatting on trademarks in different parts of the world, and I guess maybe trying to get leverage if somebody wants to, access to that.
Yeah, we see that a lot, especially in countries like China. There's a lot, people, we call them typo squatters. They'll take either the famous mark and shift a letter around in it, or even take a mark that hasn't been registered in another country and try to register it first. That way, when the brand owner tries to enter into that market, they're like, wait a minute, someone else has a registration for my mark with my goods in this country. This can't be.
Yeah.
And then once you try to fight that battle, they say, sure, we'll sell it to you for, some absorbent fee. And it's a practice that we see way too common, which is another reason why we advise our clients, if you are already using it, or if you have planned to use your marks internationally, it's advisable to get that stake hold in the ground early to prevent squatters from doing that.
Yeah, it makes a lot of sense. Andrea, this has been great information. Is there anything, as we wrap up here, that you'd want to leave the M&A Unplugged community with as it relates to this topic?
Yeah, one thing briefly that we didn't get into was counterfeiting. We mentioned about the differences of using versus registering marks. And in the United States and a lot of other foreign jurisdictions, it's important to register your mark because you can record registrations with the customs offices in those countries to prevent, or to at least have some type of an enforcement mechanism against counterfeiting coming in. So I know we didn't get into too much about the benefits of registration versus just use. But one of the main benefits that I do want to leave your audience with is that if you're having any issues with counterfeiting, with someone using your mark on products that you didn't authorize in, China, for example, that are coming into the United States, if you register your mark with the U.S. Patent and Trademark Office, you then can register that with the Customs Office, and Customs will stop those on their own without having to initiate any type of criminal proceedings. So that's a really good enforcement mechanism.
Oh, that's great.
And a big benefit to making sure that you do register your marks if you're using them with goods.
Oh, that's great. Great advice. Well, Andrea, again, thank you so much for being here. If anyone in the M&A Unplugged community wanted to get in touch with you about this topic, how could they reach you?
Sure. I'm always available by phone. My number is 312-269-5347. And I am available also through email. It's afuelleman@nge.com. afuelleman@nge.com. I'd be happy to talk further in greater detail if there's anything that I've mentioned that sparks further interest or further conversation.
Awesome. Andrea, thank you so much for being here.
My pleasure. Thanks for having me.
So M&A Unplugged community, I think Andrea pointed out some really important things today, especially as it relates to M&A transactions. And if you're an acquirer of a business, you really want to make sure that you're getting clean title to any copyrights or trademarks and that there aren't potential infringements out there, because I don't think a lot of people go through the diligence up front when they come up with these marks, whether it's product names or company names or logos or taglines, to make sure that they're not infringing on another company. And I think it's really important to make sure that you're getting clean title. And as Andrea said, you really want to make sure that you've got that to protect your brand asset. All of today's information will be available in the show notes. If you would like to learn more about the process of acquiring or selling a business, please visit our website at sunacquisitions.com, or feel free to reach out to me at drinaldi@sunacquisitions.com. I look forward to seeing you again on the next episode of the M&A Unplugged podcast. And until then, please remember that scaling, acquiring, or selling a business takes time, preparation, and the proper knowledge.
Thank you for joining us today on M&A Unplugged. If you enjoyed the show, please subscribe, rate, and recommend it wherever you get your podcasts. If you want more great information on how to scale, acquire, or sell a business, please visit our website at sunacquisitions.com.